The last few days, there's been two recent decisions on injunctions. One was the Idaho ban on trans athletes, and basically a federal judge and then a federal appellate panel of judges, three judges, stopped enforcement of the ban through the injunctions. And the other case that came down was a California case, whether or not financial control can beat domestic violence. And basically, through the injunction process, the courts can stop financial control through a DVPA, Domestic Violence Prevention Act restraining order. So somebody asked me, "Hey, what do you need to do to get an injunction?" Basically, where a judge tells someone to do something or not to do something, and I said, "Well, there's an acronym, BLIMP, that lawyers use when they get up and argue. It's balance of hardships." Which we'll talk about. Basically, is one party going to be adversely affected by either issuing or not issuing the injunction? And then likelihood of success on the merits. When you actually go to court, who's going to win that trial? If you're going to lose, the judge is very unlikely to issue a restraining order against your interest or in favor of your interest, depending on what's going to happen at trial. And then there's irreparable harm. Basically, will money satisfy? Generally, if there's a lawsuit, people ask for money first. If money can't really undo the harm, then injunctions can be appropriate. And then maintain status quo. Generally, if everything's going along okay and people aren't getting killed and injured or financially ruined, the judges will generally not disturb that unless there's really good reason. And then the last one is either public policy or property interest in order. And those are the five standards. So BLIMP, balancing the hardship, likelihood of success on the merits, irreparable harm, maintain status quo, and a property interest. So for like in the DVPA, the California DVPA part of the case, allowing financial control of one spouse over the other, or versus, balancing the hardships versus providing marital resources to both parties so they could go ahead and effectively go through their divorce or survive. And on the injunction part, so basically the Idaho ban said that if an athlete competed or was going to compete and one of the coaches or another athlete challenged it, that person couldn't compete until they underwent a medical procedure to verify, basically a gynecological check. They check their lady parts to make sure that the person was actually a female, or they'd have to do DNA testing or blood tests to determine whether or not they were. So in balancing the hardship, making a woman undergo a medical procedure when someone challenged them versus keeping men out of women's sports, if you balance the hardship, the intrusion into the woman's medical privacy much more serious. And then the other one, the second one is likelihood of success on the merits. If there's financial control, if financial control is asserted by one spouse, then it's potentially abusive, and then you can fine for a DVPA protective order. On the other side, making women undergo medical procedures when someone challenged them. We have a lot of privacy protections under, especially California Constitution, but the U.S. Constitution. There's some, it's interesting, but there's enough right into it where privacy is actually a constitutional right. Then the next category is irreparable harm. So the victim's continued abuse, either psychological or physical, is irreparable harm. Money can kind of pay the person back, I guess, if there's a lawsuit, but if the other person doesn't have any assets, the fact that you stop the victim's abuse is definitely irreparable harm, or taking care of, remedying, fixing irreparable harm. And then the irreparable harm of making young girls, athletes, undergo these medical procedures, or at least a gynecological exam to determine whether or not they're male or female. And then maintain status quo. Spouses have a 50% property interest in any marital assets, at least in California. In other places, I know it's a little different. And maintain status quo, that's the way it is. You have at least in California, community property. There's 13 community property states where you have a right to half of those assets. The fact that one husband can withhold it is not maintaining the status quo. And then generally, it's been held for a long time. You can't force somebody to undergo a medical procedure. There's a lot of Native Americans were sterilized at one point. Supreme Court goes, you can't do that. You can't sterilize people. You can't invade their medical privacy. And then the last one's property interest or public interest. And with the public interest on the domestic violence restraining orders, obviously, I just mentioned that the each spouse has a 50-50 interest in it, in the money. And on the other side, the public interest is forcing, the government can't force women to undergo gynecological exams, typically, unless there's a really good reason.